Wow, a sharp rebuke, probably the worst one I have ever read against Donald Trump and his lawyers. And yes, welcome to the No Stay Project. I'm Mark Stevens. And yes, I know that judges do this all the time, but we're talking about someone who is the former president of the United States and lawyers, very high-priced lawyers. This is not in response to anything that I filed. No, this is from the elite. Now, I know it's not holding this guy criminally accountable. He should have been in prison a long time ago, should have spent the last part of his life in prison and dying in a cold cell somewhere. But it's still nice that someone who's rich, some rich, elite douchebag, is having some accountability. He's probably not going to pay this. So if you see this, the Trump and lawyer ordered to pay $1 million for bringing frivolous lawsuit against Hillary Clinton. So what? It's not just that he's losing this, it's that he's losing to Hillary Clinton again. In a scathing ruling, U.S. District Court judge writes, misuse of the courts by Mr. Trump and his lawyers undermines the rule of law. Remember, this is not me. Okay, this is not the one, all right? This is not just some internet nobody. This is the former president of the United States and a very high paid lawyer. I don't know if he's paid him or not. He's got a history of not paying people. In fact, his history of not paying vendors goes back decades. I mean, that's just something that's baked into the Trump name, not paying your vendors. So what I want to do is I want to go through this. This is, again, you don't see this very often. So this is the actual case here, Donald J. Trump versus Hillary Clinton et al. It's an order on sanctions, because the whole thing was tossed out a number of months ago, but now they have actually issued almost $1 million in sanctions and attorney's fees.
$1 million.
Wow. This case should never have been brought. Its inadequacy as a legal claim was evident from the start. No reasonable lawyer would have filed it. Nice. Intended for a political purpose, none of the counts of the amended complaint stated a cognizable legal claim. 31 individuals and entities were needlessly harmed in order to dishonestly advance a political narrative. A continuing pattern of this, oh my gosh. Now keep in mind, I'm not a lawyer, never claimed to be, but I have held people in court and whatnot, in and out of court, to defend themselves against attacks like this in the courts. I have never, there is not a single order even coming close to this rebuke. A continuing pattern of misuse by the courts by Mr. Trump and his lawyers undermines the rule of law, portrays judges as partisans, and diverts resources from those who have suffered actual legal harm. Now, I will point out that, yes, I have portrayed judges as partisans, but I can actually back it up. Unlike what Trump is doing, I backed it up. So, for example, I got to give an example here. I helped someone in California. It was an IRS case. They said we made nothing but conclusory statements with no supporting facts. And I had a transcript of a phone call from the IRS agent as support. And we had a CD. And the district court judge ignored it. And the three judge panel appeal judges also ignored it. They said the same thing. Conclusory statements, no actual supporting facts. That was not true. So, yes, judges can be partisan hacks. Very true. Trump was not able to demonstrate that here. So this is a scathing rebuke. All right, so let's get into some of this. I'm not going to go through the whole thing because this would be like a 2-hour video, which I highly recommend, and I'll put the link in the description. You have got to read through this. This is really, really good, especially if you're interested in defending yourself in court and what you can expect. But you got to keep in mind, you and I are not the former president. You and I are not rich. I'm assuming most of the people watching this are not filthy, filthy rich. So this is on page 14. The plaintiff consistently misrepresented and cherry-picked portions of public reports and filings to support a false factual narrative. I honestly think if you're filing false factual narratives and you're knowingly filing false things, I think a contempt charge is in order. Put them in jail. Put them in jail. That's what they would do to someone like me. In fact, we know, and there have been enough reports when I did the show, that just asking judges questions has landed people in jail for contempt. Here, the judge is soundly rebuking these people. Hey, exercise the power of contempt. Have Trump and his attorneys arrested for filing this crap. You do it to me. You do it to the little people. Often the report or filing actually contradicted his allegations. Again, not something I've ever been accused of. It happened too often to be accidental. Wow. It happened too often to be accidental. Its purpose was political, not legal. Again, contempt. Arrest him and his lawyer. Factual allegations were made without any evidentiary support in circumstances where falsity is evident. So it wasn't just that he was lying. It was obvious to everybody with half a brain. He was lying consistently. And this is what gets me. It's nice to see some accountability. He's never going to pay, and he's going to appeal it. There's two systems of justice worldwide, not just the United States, but the United States is bad because the PR is always, it's so fair. If I had done that, I would be held in contempt. I would probably go to jail. And again, I used, well, Mark, you're talking, there's a big difference between traffic court with very little oversight and a federal court. It doesn't matter. You have, as a matter of course, a lot of us have been threatened with contempt, and some it's been carried out where they were handcuffed for asking questions. Now, you could argue, well, they weren't relevant questions. Okay, I'll even give you that. Let's just say for sake of argument. They went to jail for that. And why, when you have factual allegations made without any evidentiary support in circumstances where falsity is evident, and it says that it's happened too often to be accidental. It's happened often. So you've got a guy who's clearly abusing the legal system. Contempt. If it's contemptible for me to ask a question, an irrelevant question, I'll give you that. If it's contemptible for me to ask an irrelevant question, why is it not contemptible for someone to, as the judge saying here, is making false statements very often and doing it for a political purpose, not a legal one? All right, so then we get down here to subsection C. The plaintiff's legal theories were frivolous and foreclosed by existing precedent. Remember, this is the former president, not me. There's a much higher standard here. And these are presumably very experienced, high-cost attorneys. The plaintiff recklessly advanced claims foreclosed by existing precedent that the most basic legal research would have revealed. That's a violation of Rule 11. It was not that the complaint and amended complaint were inadequate in any respect. They were inadequate in nearly every respect, even after the deficiencies had been identified in the multiple motions to dismiss. Again, highly, again, we've got here very high-priced, experienced lawyers being hit with something, I've never had. I have never, and you can go and you can look, I have never been rebuked like this by a court. Never. Never. Wow. Inadequate in nearly every respect. Wow. The 11th Circuit has squarely held that to knowingly advance frivolous claims constitutes bad faith, meriting sanctions under a court's inherent powers. Put him in jail. Is a peer case reversing district court's failure to award sanctions under inherent powers based on circuit court's finding that lawyer, quote, knowingly pursued a frivolous claim and thus acted in bad faith. Put them in jail. The plaintiff does not even attempt. Oh, man, my gosh. The plaintiff does not even attempt to respond with respect to most of the legal failings of his claims. To reiterate a few, the malicious prosecution claim without a prosecution, the theory of personal jurisdiction based on an allegation that the defendants knew that Florida is a state in the United States, which was an important one, the trade secret claim without a trade secret or ownership, the computer fraud and abuse claim foreclosed by Van Buren versus United States, obstruction of justice untethered to any official proceeding. Wow. Despite its 193 pages, the amended complaint did not come close to stating a legal claim. That was never its intended purpose. Wow. A pattern of abuse of the courts. Again, experienced, high-priced attorneys and the former president. I've never had anything like, I've not had anything, even with the worst of judges that I've had to be in front of, like Lex Anderson and Pep Guzman here in Phoenix. None of them had anything close to what they're saying here. I have explained why the totality of the problems with the complaint, amended complaint, and the arguments and statements of plaintiff's counsel show that this lawsuit was filed and prosecuted in bad faith. Put him in jail. But this case is part of Mr. Trump's pattern of misusing the courts to serve political purposes. Federal courts have both the inherent power and the constitutional obligation to protect their jurisdiction from conduct that impairs their ability to carry out Article 3 functions. Thus, while litigants' conduct in other cases would normally not be relevant, when the court is faced with a sanctions motion against a repeat offender, undeterred by admonitions, because he's so wealthy, because you let him get away with it. I gave you a chance and you blew it.
And you blew it.
It has the authority to consider that litigant's outside conduct. Mr. Trump's deliberate use of a frivolous lawsuit for an improper purpose constitutes bad faith. No kidding. And the behavior is not unique, but part of a plan, or at least a playbook. The telltale signs: provocative and boastful rhetoric, a political narrative carried over from rallies, attacks on political opponents and the news media, disregard for legal principles and precedents, fundraising and payments to lawyers from political action committees, and when a ruling is adverse, accusations of bias on the part of the judges, often while the litigation is ongoing. Consequences. Having determined that sanctions are appropriate under inherent authority, I must now determine what those sanctions should be. Jail. I find that an award of defendant's attorney's fees and costs is a fair and just sanction given plaintiffs and his counsel's actions in this case. What follows then is an analysis of what amount of fees and costs is reasonable. I'm not going to go through all that. And we get to one of the best parts. Defendant's motion for sanctions is granted. Plaintiff Donald J. Trump and plaintiff's lead attorney Alina Habba and Habba Madeo and associates are jointly and severally liable for $937,989.39 by Donald M. Middlebrooks, a United States District Judge. So it's nice to see, even though he's never going to pay, some accountability, just some. Of course, yes, he deserves to be in prison the rest of his life. He should die in a cold prison cell. Absolutely. Not going to happen, because that's not what happens to rich people unless they go after other rich people. This is good. This is good. And as I said before, you can't look at this through the lens of it happening to me or a regular person. This is happening to the former president. Someone very wealthy, maybe not as wealthy as he claims because he lies about everything, but somebody very wealthy who is the elite of the elite, meaning this guy's a former president, and having, experienced attorneys who apparently will do anything for money. Now, he'll get out of paying for it, but the attorneys, probably not. Probably not. So kudos to this Middlebrooks judge. But although, by the same token, I do have to point out, whatever good that he did here, if it was the IRS against me, he would ignore everything on behalf of the IRS. That I have no doubt. Plenty of evidence of federal judges being, judges of all stripes, being partisan hacks. Plenty of evidence of that. But this is good. This is good. I like to see this. So that's going to do it for this video. I highly recommend going through, reading the whole thing, because the judge does an exhaustive analysis, and that's something that if I'm going to court, you know, this is something that I would need to do so that I could adequately defend myself. I need to know all this, and it's a good exercise. It's a good way. It's a good tool to help learn how to tear apart a legal document, how to take a legal pleading and tear it apart, because the judge does a fantastic job. I'm sure he's doing it based on what the staff attorneys are doing, and also the pleadings that were filed on behalf of the defendants. It's really, really instructive for us if we're looking to improve our legal education, and especially if we're looking to defend ourselves in the courts. So definitely check out this order on sanctions. That's going to do it for this video. Thanks for watching. If you'd like to help support the No Stay Project channel, you could do so in the description. You can get an awesome shirt like I'm wearing now. These Anarchy shirts are made right here in Arizona. And you can also get ebooks of Adventures in Legalland and Government Indicted. Just check out the links in the description. And again, thanks for watching.
And you blew it!